Terminations are rarely a positive experience. There can be some exceptions, but for the most part, they're going to occur due to significant events that may have happened on either the company or the employee's end. And in the realm of equity compensation, there are going to be a multitude of ways in which we can go about handling these situations. In this video, I'm going to be providing you a high-level overview of the 5 possible treatments that can be taken once an employee is no longer with your company. So as we begin, let's first look at some of the reasons an employee's employment status may have changed to begin with. What we have listed here is death, disability, retirement, and reduction in force and other layoffs. Of the reasons listed here, honestly, they can all have the same treatment or wildly different ones. So many factors come into play when determining what actions need to be taken upon any of these termination reasons. But when deciding what needs to be done, your Bible is going to be your governing plan document and the awards agreement. The information listed there is going to be your guide in determining what action should be taken and what benefit, if there is any, is going to be extended to that former employee. However, before I move on, I want to make sure that it's understood in the context of global equity plans, things are much more convoluted and nuanced. This video, again, is meant to give a high-level overview of the standard treatments we see upon termination, but for those looking to gain a deeper level of understanding, the first place you need to look is the NASPP webinar titled Global Equity Plans and Life Events, Strategies for Success, presented by both Amy Sudan and Jennifer Kirk of Baker McKenzie. The sheer amount of information that they provided was incredible and is a needed watch for anyone who has a global population. Now, as we get right into it, let's look at the first treatment, and the one we have here is forfeitures. Now, forfeitures are pretty self-explanatory. What that essentially means is upon termination, the award is going to be going back to the company. Now, exactly what is going back to the company is going to be determined by how the governing plan document is laid out and how the award agreement itself is stated. For the most part, and the most common treatment, is upon termination, the unvested portion of the award, if it is something, say, like options, is going to be returned to the company upon termination. There are exceptions that we're going to be talking about later on, but for the most part, that is the best way to think about forfeitures. Unvested options, termination, the unvested portion is going back to the company. Now, for the next aspect of it, we have accelerations. Accelerations can happen both fully and partially, meaning for that unvested portion in the last example that was forfeited and returned to the company, if the plan and agreement states so, the award holder can actually have the unvested portion accelerated and become vested. Now, that can be both fully, again, or partially. It doesn't have to be the full amount. It can be the partial amount. It just, again, is going to depend on your company's specific plan and the agreement itself. And one thing to note is when we did this webinar presented by Amy Sudan and Jennifer Kirk, from the attendees and the polls taken, we saw that this was typically the most common treatment associated with death and disability. Now, for the next one, we have continuation. And continuation, like the name states, is just a continuation of vesting. This is something we see more common with retirement, meaning that having the award vested is a way for the company to further enforce a non-compete. So with this award and what they have out there with the continuation treatment, if something is unvested, in the last examples, we had a forfeiture where the awards were returned back to the company. An acceleration, the unvested portion had their vesting accelerated. But in this situation, the vesting just continues. There's no acceleration. It's just things continue as if the termination had never occurred. It's not the most common, but it does happen, and something, again, that we see most common with retirements, though it's always going to be dependent on your specific company's needs and goals. For the next treatment, we have a replacement benefit. This one, at least in my experience, is typically the most rare treatment that can happen upon a termination. And the most common treatment that happens here is, say you have an award where the value is $500. Very cheap, I know, not much, but it's $500. And that replacement benefit is typically going to be cash considerations for the value of the award. So instead of the former employee retaining that award, they're actually going to receive the monetary benefit that was associated with that award. Again, it can vary by company, but the most common thing that we see is cash considerations, which mean that $500 value is going to be sent to the employee in the form of cash. Now, for the last treatment, and something I'm sure all of you are familiar with, is an extension of the post-termination exercise period. So with a post-termination exercise period, you can have a multitude of ways in which your company is going to enforce that. If it's a voluntary termination, Typically, the company will have 30, 90 days. Again, it's going to vary on a case by case basis, but the post termination exercise period itself is just going to allow the employee to exercise their award for an extended period of time. When we take it back into the realm of the other treatments we had discussed, say accelerations and continuations, what essentially a post termination exercise period means is, hey, you have your vested awards, and at this specific period, you have to exercise this award, and if you don't, that award becomes forfeited. So the post termination exercise period is something that the company has signified as being the amount of time they would like to give this former employee to exercise their right to obtain the shares from, say, a stock option. Again, this is going to be on a case by case basis, and the termination exercise period can have differing values depending on what that termination reason is. For terminations with cause, typically we see that termination exercise period being 0. So upon termination, everything is going to be forfeited. If it's without cause, typically they can give 30 to 90 days, though again, it can vary by industry and company goals and needs. All right, so that is a quick rundown of the 5 possible treatments that can occur whenever an employee is terminated and no longer with the company. The information we listed here was a very high-level overview, and again, for those that have watched, we are going to highly recommend that you check out the NHP webinar presented by Amy Sudan and Jennifer Kirk. It's a great way for you to increase your equity knowledge, and especially in the realm of global equity plans where things are much more convoluted and nuanced. Again, thank you for watching. We hope you enjoyed the presentation. And if you did, please give us a like and a thumbs up and follow us on LinkedIn. Thank you.